Please tell us your name and roll number.
My name is Sambit Das. Roll number is 100-826.
You are a practitioner?
Yes, sir.
Where?
Bhubaneswar Court, sir. Bhubaneswar Court.
Bhubaneswar.
Who is your senior?
I was practicing under Chittaranjan Das, criminal practice.
Criminal practice. So, will you please speak few words on your academic performance?
Sir, I graduated from my law in the year 2017 from University Law College, Vanivihar. Then I did my masters at Mayurbhanj Law College and graduated there from 2019. Meanwhile, I had started my practice. I got my license in the month of May of 2018. Then I started my criminal practice and I was working till mid of this pandemic. Around second wave, I was still practicing. Then I took a break and was studying.
But still, when you are continuing as a member of the
yes, sir. Yes, sir.
Are you conversant with the duties and responsibilities of the assistant public prosecutor?
Yes, sir. I am mostly. Yes, sir.
What is the main responsibility of the APP?
Sir, the APP APP is on behalf of the state government. Whatever case is filed, state is one of the parties. That case is represented by APP in the magistrate court. In the magistrate court, his work is to represent the informant who is the informant. Represent until and unless the informant actually hires a private advocate. Informant, and also it also works on behalf of the police officer to get a arrest warrant or search warrant or something like that. The APP is the government of the advocate. Whatever a advocate does, he does that, but on behalf of the government.
Were you interested for this job?
Sir, I was fascinated by this practicing. I love my job. Sir, this job profile actually suits me. I will be doing the same thing I will be doing, same prospects I will be doing with same enthusiasm I will be doing, but I will have the option and chance to represent the people who actually need it. When I am doing private practice, I am representing actually someone who is guilty. Sometimes I am representing guilty. I know that, but here I will be chance actually who is a victim, and that will make me feel nice. Plus, the job prospectus is very nice, and it gives me a stability too. So I am interested for a professor.
You are connected to the practice how many years?
Sir, I started in the year 2018. 3 years, sir.
3 years.
3 years.
Within these 3 years, can you elaborate what is your practice experience?
Sir.
What are the cases specifically you have done, or that you have assisted, or that you have prepared?
Sir, I have experience in numerous cases because I was doing in a well-to-do chamber and we had numerous criminal practices. First 6 months went putting hajiras in this court, 317 petition. This first 6 months went there. Then I was allowed to stand and make arguments in the JMFC courts. I have also done some bail matters in High Court as well as Sessions Judge courts. And I actually love this job because it gives me a self-satisfaction. I like to get prepared for the next date. I like to take that pride in putting pressure on the other party. I love this job. I cannot express what I am saying, but I just love this job.
How a document is exhibited?
Sir, document is exhibited when as a witness, as a evidence it is exhibited. Sir, there are two types of marking it. When prosecution comes, it is marked in numbers A, 1, 2, and on behalf of the defense, it is marked in A, B, C. But however, I have come to know that in last 2 months, it has changed. Now it is being marked as exhibit. If it's from prosecution, P1, P2, and if it is for defense, then it is being marked as D1, D2.
So suppose you are working as a APP. Now in a sensational case, when the informant was called to depose, you got the notice that he has died, he has expired. Now the FIR is to be exhibited, has to be proved. So how you prove the exhibit FIR if the informant is died?
Sir, informant dies does not mean the proceeding is ending. I will first for my first work as a assistant professor, I will take time. I will pray the court to give me some time to think upon it. Then I will most probably ask, see if any legal hair are there or relatives are there who can move forward with this case, or I will take help of my senior. I am not.
So do you mean that on death of a complainant, the prosecution is abated or something? What is the role of their legal heirs?
Yes, sir. Upon the death of the victim, actually the prosecution is abated.
The death of the victim, the prosecution is abated.
Sorry, sir.
It's never. Because the complaint is with the state.
Death of the
accused. Now, how to prove that particular affair? Where the author is. So now you have to search for somebody who is acquainted with his
facts and cases.
Somebody must have received it.
Yes, sir.
In the police station, somebody must have received the affair. No? Victim must have come and placed that. Yes, so, because he has died, so through him, he is acquainted with the signature or something. Verify. There are numerous laws on this subject. This is very complicated because in this particular APP, they will try to take practitioners.
Yes, sir.
That is easy for them and they will be better. And most of the entrant, those who are participating, they are not real practitioners. If you have a real practice, with that you can impress, then okay. Another thing I am asking, that what is the bar strike? Suppose the bar made a resolution that we will abstain from the court, and you are a PP. You are not a bar, maybe I don't know whether you will be considered as a bar member or not. And so what will happen on that day?
Sir, as per rules, as per my practice experience, I have seen bar strikes will not affect the work of a APP, because if any member comes, bar strike is local strike, or Bhubaneswar bar has gone to a strike. Bhubaneswar advocates are abstaining from job, not if someone comes from Cuttack, someone comes from Sambalpur, he is not abstained. So if someone comes, then APP should be present. APP has no work with the bar strike. He is for the government. How can he support a strike and all? He is for the government. He will sit in the.
Can go on strike.
Sir.
What is the law?
So,
whether advocates can go on strike.
Sir, there are numerous judgments. What I know is it should not go on strike. It is not right to go on strike on and because we are going on strike, but look, normal peoples are being affected from it. The general public is getting affected. They are coming court with lots of hope.
Suppose a witness has come to the court, right? And witness is examined. Then what is the process to stall the cross-examination?
Witness has already come.
Yes, already examined. Now you don't want to cross-examine him for the day. You want to stall it. So what is the process?
So I will fall sick. I will fall sick. That is the first thing.
Okay. So suppose an adjournment is sought for.
Yes, sir.
In the courtroom because the witness is present. Now the adjournment is refused. You say that I fall sick, but adjournment. What is the law on that? Whether magistrate is bound to give adjournment or that what are the circumstances that adjournment can be given or refused?
Sir, a magistrate can only adjourn if a witness is there, only if it has reasons. It has compelling reasons to do so. Otherwise, is not bound and should not also, because there are lots of pending cases only due to this issue. And the remedy, if adjournment is not given and rejected, adjournment petition is rejected, is I can go in a revision. As not as a APP, I am speaking about as a private attorney. I have seen once in our code, JMFC, lady JMFC had came. She was very strict and she was rejecting all time petitions. She was not giving time. If you are, she was taking adverse actions. So advocates used to go to district judge and session judge and file revisions. So session judge.
Rejecting an application for time is a final order or an interlocutory order?
Sir, interlocutory order.
Does a revision lie against an interlocutory order?
Sir, I have seen doing that. I am not clear on that point, sir.
What normally happens in the sessions court?
Interlocutory order should not go, but
how can you say rejection of an application for time or anything? How it can be interlocutory order? What is an interlocutory order? To your understanding,
sir, any order which is not finalized, some more is there.
For that purpose.
For that purpose, yes.
Now
Sir.
he closed.
Final. Then
The
final
moment
order.
he rejected that application,
final
means
order.
it's closed.
Yes,
Means
sir.
evidence is closed.
Yes.
For that, so till it is a final order. It's
Yes,
not
sir.
an
Yes, sir.
introductory order. No.
Sorry, sir.
As I suppose a proceeding from 144 to 145 has been converted
Sir.
by the police or the. Now, what is the remedy applies here? What you will do? Somebody has come with you with a.
Sir, we can go to the appellate court of 144 court is decision session judge. We can go there. We have to file our grievance there.
So suppose there is a 144 proceeding and there is a stay or something. 145 is converted, and similarly, one of the party has gone to the civil court and got a stay or status quo, injunction, something. So what will operate?
The civil, the order of civil court will operate.
Why?
Sir, I don't know the reason, but that's what I have seen.
Binding of a civil court, binding on all courts, including Supreme Court. That's the law. Strict. Binding of a
Civil court,
binding on all courts, including Supreme Court. If there is a finding in any appreciation, even in a model case, if there is a finding with regard to a proposition, then that has to be relied and that is proved.
आपन जानते इस्टोपेल कौन?
Yes, sir.
कौन सेटा?
इस्टोपेल हला गोटे जिनस मु कहली धर मु मिस्टर ए आ जन अच्छा मिस्टर बी मु मिस्टर ए को किसी गोटे जिनस कहली और मिस्टर बी मो कथा शुणिकी ही बिलीव दैट एंड डिड सम एक्ट ऑन दैट बिहाफ तापर मु आ कहि परिबिन जे ना ना से टाइम रे मु जोटा कहितली सेटा ठीक नथिला एबे जोटा कहूची ठीक सेटा मु परे कहि परिबिन फॉर एग्जांपल मु गोटे प्लॉट देखैली मिस्टर बी को ते एटा जमीर मालिक मु आ मु एटा बिकिबी मु एडवांस नै आसली पर सीटा मो बापांकर थिला बापांकर देहांत पर सीटा मोर हबो हेला पर मु कहली ना ना जेतल मु कहितली सेतल मु ओनर नथिली तन सेटा फ्लक्चुएट होची एई दिन सेटा मु कर परिबिन यू आर स्टॉप फ्रॉम व्हाट यू हैड क्लेम्ड अर्लियर एटाला स्टॉपल
एस्टोपल काहे अगेंस्ट लागिवनी देयर इज नो एस्टोपल
अगेंस्ट द गवर्नमेंट
सर
सॉरी बुझी पेले एक्चुअली
देयर इज नो एस्टोपल अगेंस्ट लॉ
सर yes sir yes sir
there is no एस्टोपल अगेंस्ट
don't confuse
एस्टोपेल तारो एस्टोपेल तार केटा डिवीजन अछि केते प्रकार एस्टोपेल
अरे सेटा मु जानि
अच्छा अच्छा बट बेनिफिट ऑफ डाउट इट आपन ओडा लीगल टर्म अछि कौन सेटा हाउ इट इज वेयर इट इज एप्लीकेबल
सेटा सर गोटे प्रोसीडिंग रे गोटे धर गोटे कोनोसी क्रिमिनल प्रोसीडिंग रे अक्यूज डिफेंस को देते बेनिफिट ऑफ डाउट जेतमन तो माने से गोटे माने जन को चांस दिया होचे निजको ये करिया पे जस्टिफाई करिया पे सेटा को ही बेसिकली बेनिफिट ऑफ डाउट को जेंति गोटे अक्यूज को ही इज प्रिज्यूम टू बी बेनिफिट ऑफ डाउट दिया होचे जे से इनोसेंट अनटिल अनलेस प्रोसिक्यूशन पूरा केस टा को बियॉन्ड डाउट बुझौची केस को रिप्रेजेंट कर दोची
Tell me whether a statement can be a conduct, mere statement.
Yes, ma'am. For example, there is a rape, and the rape victim goes to file an FIR. That statement also comes under Section 8 of Evidence Act.
Only statement. I am only talking about only a statement whether can be relevant.
It depends upon situation, ma'am.
So can you tell me explanation 1 of Section 8?
Sir, ma'am, don't remember it right now.
Only statement cannot be a conduct unless it is accompanied by some act.
Yes.
मतलब ଗୋଟେ क्वेश्चन आंसर दिल रे अपन गाड़ी बहुत स्पीड रे नेग्लिजेंटली चले के जाउ छथि रैशली अपन के सामने 10 जन अछथि अपन देखु छथि 10 जन अछथि पूरा रोड मझे छिड़ाई छथि अपन स्पीड कमेलिनी तंबो ऊपर चढ़े की पड़ेली सो अपन को अंडर रे चार्ज अपन को लगे को सेक्शन रे
सर आईपीसी मैम आईपीसी रो 279 लगियो रैश एंड नेग्लिजेंट ड्राइविंग
डेथ
गला 304 है
304 है तो मते कहंतु जदि आपण देखुछंती 10 जन अछंती आपण गाड़ी चढिले तांको ऊपर व्हाट इज द इंग्रेडिएंट अंडर 304A रैश एंड नेग्लिजेंट एक्ट राइट एंड हाउ इट इज डिफरेंट फ्रॉम
299 रे इंटेंशन इज द मेन थिंग मु रैश एंड नेग्लिजेंट ड्राइविंग चलोतली किंतु मु काकू मारिया पे सेमती चलो नथली
बट मुझे देखुछि मो सामने 10 जन अछंती मु स्पीड कमली चढिली वेदर दैट विल बी कमिंग अंडर माय नॉलेज और नॉट इंटेंशन आई अंडरस्टूड मोर मारिया को इच्छा नथला बट वेदर आई हैड दैट नॉलेज और नॉट
नो 299 नॉलेज रो थाए किंतु 304 नॉट ना
तो इस सिचुएशन रे अपन को 299 रे लायबल करिवे ना 304A रे लायबल
304A तो स्पेसिफिकली सिट में हेई छी ही सेही दिनसो पे
जदि मु जण को देखुछि सामने रे छेड़ै छी और तथापि मु ता ऊपर गाड़ी
नहीं जदि मु जाउची से मो रास्ता मझिरा आसला मु तापरे रन ओवर कर देली अलगा दिनसो आ मु त गोडे गोडे रन ओवर करली सेटा उट अलगा दिनसो
मते बस 10 जन अछंती रोड रे मु पूरा जानि छी कि 10 जन ऊपर मु गाड़ी चढ़ी के पळेली मोर नॉलेज अछि मु गाड़ी चढ़ी देली then whether I will be still held liable under 304A or 299 culpable homicide liability
304A ही होबो मैम
it should be culpable homicide right because more knowledge अछि 304A start code color when a thing is not culpable homicide mean if there is no intention and knowledge then only I will be held liable so there will be circumstances जोडे आपण खाली रोड रे गाड़ी चलो छथि but so rashly and negligently कि आसले आपण ब्रेक मारले भी अटकी बनी गाड़ी तो जदि सेही टाइम अपन चढ़े देले you will be held liable under 304A but if you had knowledge you will be liable under culpable homicide right because knowledge is not an ingredient under 304A now tell me what is the difference between self preservation and private defense
private defense तो 96 रे explain करूची in private defense I have right to prevent myself as well as myself, my body, my property, as well as some other person's body and property. Right. Self preservation is my what माने preserving myself. For example, flight रे जोटा धर जो कहउचंदी केबिन प्रेशर हेले एयर मैक्स ता आसी जीवो मु आगो पिंदी सेटा ला सेल्फ प्रिजर्वेशन जाउची
सेल्फ प्रिजर्वेशन रे काहर डेथ करि परिबे
नेसेसिटी नोज नो लॉ एटा गोटे केस लॉ अछि स्टीफेंस वर्सेस रे सेतरे से माने बोट रे थिले चार जण आ समुद्र रे खाइबा पे से माने जण को मारिया पेला
तो से माने लायबल हेथिले ना
हे नथिले केना एटा नेसेसिटी थिला एटा
नेसेसिटी अंडर आई कैन किल समवन इन ऑर्डर टू सेव माय सेल्फ जदि काली कोविड सिचुएशन या फिर एमिति सिचुएशन हे जाउ जे के मो घर आ मो आखबो के नेबर धरो साइक्लोन होची आ बिल्कुल केही नाहंती मो पड़ोसर गोटे कुनी
ना किछि गोटे ये माने अल्टरनेटिव थिबो जदि जेंते केमति हबो किछि
नहीं आमी तीन जण धरो बोट रे जाउछु आ बोट रे समुद्र रे हजि गेलु त आम भितर जे सबठो वीक मेंबर अछि आमे तो मारी के खाइ देलु एंड आमे ऐसे कहलु कि सेल्फ प्रिजर्वेशन थिला आमे तो मारी देलु
नेसेसिटी थिबो माने आइदर तमे आपण बंचितांते नले से
तीन नाम को आम सोल्जर माने काई बंचोचंती दे आर सैक्रिफाइसिंग देयर लाइफ फॉर अस एंड वी आर किलिंग समवन इन ऑर्डर टू प्रिजर्व अस देयर इज अ रूल सेल्फ प्रिजर्वेशन के आपण डेथ करि परिबनी ओके एटा देखि ले डेटाबेस स्टेटमेंट में कहथिला हे परिबनी सेल्फ प्रिजर्वेशन इज नॉट एन एब्सोल्यूट नेसेसिटी आई कैन नॉट कॉज डेथ ऑफ समवन इन ऑर्डर टू प्रिजर्व माय सेल्फ राइट स्ट्रगल रे हे परिबो तार दीटा एग्जांपल आपण देख देबे वुडन प्लैंक रो एग्जांपल अछि इफ दी जण जाउछु देन मु ताकू धक्का मुक्का मारी के पळेली ठीक अछि बट जण जदी ऑलरेडी अछि मु ताकू काढी के गले आई विल बी हेल्ड लायबल फॉर द डेथ ऑफ दैट पर्सन ओके सो दैट्स द ओनली डिफरेंस प्राइवेट डिफेंस आई कैन कॉज डेथ सेल्फ प्रिजर्वेशन इज नॉट allowed to मते आ जण मारिया पे के अलाउ करने ओके लास्ट वन मते गोटे क्वेश्चन आंसर दे दो बस how you differentiate between English law of dying declaration and Indian law of dying declaration
so I'm not actually thorough on that part
okay can an infant give a dying declaration
can an infant give a statement I do not know
गोटे 7 वर्षर छोटा dying declaration देछि whether that will be a relevant fact the 4 वर्षर ही देछि 4 वर्षर पिला गोटे डाइंग डिक्लेरेशन दोचे आपण तोरा डाइंग डिक्लेरेशन को एविडेंस हिसाब रे प्रेजेंट कर परिबे
मैम दिस इज एक्चुअली क्वेश्चन ऑफ फैक्ट डाइंग डिक्लेरेशन पूर्व मजिस्ट्रेट की जे भी रिकॉर्ड करथुए ही मस्ट बी दैट श्योर दैट चाइल्ड इन क्वेश्चन इज एक्चुअली अंडरस्टैंडिंग एंड इज एक्चुअली इन गुड शेप टू गिव द आंसर्स एमती नै जे किछि भी कहि देला एमती नो जे से तार कंडीशन अच्छी कहया पे हां हां कंडीशन रे अच्छी ताहले से दे परबो सेटा
मते आ बस गोटे जिंस कहबे तो मु जदी जाय कि कोर्ट रे गोटे डॉक्यूमेंट रो कंटेंट विषय स्टेटमेंट देली ठीक अछि देन whether that will be my oral evidence or documentary evidence
the contents of a document रे खाली डॉक्यूमेंट्स ही देई हबो ओरल एविडेंस देई हबो
एविडेंस नथिला
सेकेंडरी देबे
तो मु कंटेंट जाय कि देली तो whether that will be my oral evidence or whether that will be coming under the heading of documentary evidence
it will come under secondary documentary evidence
right okay thank you
ठीक है तरतर हो जन कहला तो क्वेश्चन ता पचरा हो जी ठीक है 10 सेकंड जाने भाभी की तापर कहले तो जो कहवार जो तीव्रता ता कमी जीव हां तापर जहाँ कहबे आप भाभी जति कहबे तो सेटा टिके मु लक्ष्य करछ आपण शॉर्ट क्वेश्चन प्रश्न ध्यान के आप उत्तर देवा चाहूँ ठीक है सेमती तो उचित न
नॉट नेसेसरी
भाभी की तापर कहबो
नॉलेज अच्छी यही सर्विसटा भी प्रैक्टिसटा को से निश्चय टेस्ट करेंगे प्रैक्टिशनर भीतर पिला टाणी चेष्टा करेंगे मजिस्ट्रेट नदी से जाए डिसाइड करेंगे प्रैक्टिस तो ठीक है सर तो फॉर द बेस्ट
थैंक यू 10 तारीख सर थैंक यू सर